Lee Goldberg is our transactional business attorney in his 35th year of practice. Lee has extensive experience in negotiating and documenting sophisticated real estate transactions, finance matters, intellectual property licensing and protection, corporate structuring, M&A, and many other business transactions, operational strategies, and protections. Currently, the majority of Lee's practice is spent acting as outside legal counsel to numerous companies across a broad spectrum of industries, including real estate, manufacturing, retail, software, equipment, professional services, and consumer products. So without further ado, Lee, you're unmuted, yes? All right, take it away.
All right. Well, hello, everybody. Thank you for having me here today at Spark OC Freelancers Union. Thank you, Bridget, for asking me to come. As Bridget had stated, I'm outside general counsel, and as outside general counsel for various different companies, we have to deal with pretty much all issues that that address your business and that address your business's future. And a very significant issue since certainly the beginning of 2020, I happen to believe since July of 2018, has been the categorization of whether you have a 1099 contractor versus an employee. Just quickly to go over it, I am very well aware that who I'm speaking with. Not only do we have business owners that may use 1099 contractors, but I know that a lot of you are 1099 contractors. And here's the issue. I will address it. Things can be done on both sides of it. And I will address these issues from both the employment side, the hiring party side, and the independent contractor side of it. So let's jump into it. Most people understand the difference between a 1099 contractor and an employee, but let's break this down. If you have an employee as the hiring party, you are responsible to satisfy and qualify under all California labor laws. I will tell you right here, right now, I have been known to say this, I've been saying this for years. If you're a hiring party and you have employees and you do not have an in-house HR specialist, or if you do not have outside HR specialty helping you out, I will just about guarantee you, you are in violation of California labor law. It is that complex, it's that hard to follow, and frankly, it's far more expensive to have an employee than it is to have a contractor. You have to follow all wage and hour laws, all break and meal period laws, all corporate training laws or employee training laws, including the new anti-sexual harassment training. You have to obtain workers' comp for that employee. So all of those costs are associated with having an employee. None of those costs are associated with a 1099 contractor. You don't have to do withholdings. You don't have to have them sign all of the 12 or 14 federal and state documents that you need to get signed in order to hire an employee legally in the state. And that is why most people opt, most businesses opt, wherever they can, to use 1099 contractors. So for everybody to understand what the big hubbub was in 2018 and at the beginning of 2020 regarding this, is there was a seismic change of how we went about classifying our 1099 contractors versus employees. And that is as far as the state is concerned, and you'll see why in a moment. But to give you a little background, the only way to understand how seismically different things are now is to understand the way they were. And I've been in practice since 1986. That's 35 years. I will tell you in 1989, 3 years into my practice, so substantially my entire practice, the categorization of 1099 contractors and employees was governed by a California Supreme Court case called Borrello. And in 1989, Borrello came down and it said, look, we're going to look at whether you have an independent contractor or an employee on what we call the totality of the circumstances. If it looks more like you have a relationship of an independent contractor, then we'll call it an independent contractor. If it looks more like an employee, we'll call it an employee. And then the court gave 21 or 24 separate indicia of things that they thought looks more like a contractor relationship than an employee relationship. Well, that was a panacea for us lawyers, because all we had to do, and oh, by the way, Borrello required at the very least a written contract to show all these things, all these indicia. So what us smart aleck lawyers did for our clients is we prepared 10 and 12 page independent contractor agreements where we hit every one of those indicia. And it really didn't matter what the reality of the circumstances were. The EDD would come in to challenge your classification. And as soon as you showed them that agreement, they threw their hands up and walked away. Big win for business. Well, I guess that was just too much for the California Supreme Court. Because in 2018, in July of 2018, without any hint that they were going to change things around, completely put the categorization and classification upside down on its head. And they came in with, by the way, this California Supreme Court ruling was unanimous. We don't normally get unanimous rulings here in the state of California. That's how much they wanted to change things. And it's a decidedly pro-state interest, pro-employee interest ruling. And what they did was they threw out all of those 21 indicia, and they opted to choose 3 indicia. And they said you must qualify under all 3 indicia, or else by default, you're an employee. They basically said to everybody out there, you are all employees unless you can meet our 3-prong test. Now, I'm not going to go over that 3-prong test just yet because it was codified, all right, by the state. In effective January 1, 2020, a law which everybody now knows as AB-5, which was codified into Labor Code 2750.3, came into effect and said, basically parroted what the California Supreme Court said in the Dynamex case in 2018, and basically gave us a 3-part test, which has now come to be known as the ABC test. But they also gave us a little reprieve. They gave us a whole list of exceptions, specific job exceptions to AB-5, meaning you are by default under AB-5 an employee, not an independent contractor, if you don't meet this 3-part test. However, we have a specific set of exceptions that we will allow you to be an independent contractor even if you don't meet this ABC test. I'm not going to go into great history or anything, but just so you know, AB-5 is actually a misnomer. AB-5 has been repealed and rewritten as AB-2275. And that is now codified, just so if you want to look it up, in California Labor Code 2775 through 2787. All right. Now I'm going to do something a little different here. That I've given this AB-5 various iterations of this talk many, many times. It's very important to California businesses to get right. And because it's so important for California businesses to get right, I'm going to change things around a little bit, and I'm going to talk about your exposure. I'm going to talk about what the problems are for the hiring party and how they can get nailed if they misclassify and classify somebody a contractor when the state thinks they should be an employee. And by the way, it doesn't just affect the hiring party, because it affects the contractor, because you won't get the jobs if you can't qualify as a contractor. So let's start out with what the employer or the hiring party, I will call them, their potential exposure. Well, if you misclassified somebody as a contractor versus a proper classification as employee, you should have been paying employment tax for that employee. Well, that's your exposure, both state and federal. You also are supposed to be withholding their tax and their disability and Social Security. That also you will be, as the employment party, for not withholding it, you will be liable, state and federal. On top of that, you'll have an interest portion of it. Of course, everybody wants their interest. That's at 10%. And that goes from the date that you should have withheld and you should have paid the employment tax. On top of that, they really get into you because part of what you did not pay to them is employee withholding. And I will tell you, both state and federal government get very, very testy when you withhold from employees and do not pay it to them. All right? So they put a 30% penalty on the withholding portion of that. And then in case somebody wants to be a smart aleck and says, oh, I'll just do this until they catch me, and then I'll crater the company and start a new company and do it again. Not so fast, Sparky. There is personal liability of what they call a responsible party if you did not pay the withholding, meaning they're going to ignore your corporate status or your LLC status or what have you. And that withholding amount and the 30% penalty, they will come into your personal bank account to get. They're very serious about that kind of stuff. What does that all really mean? All right, let's talk in real terms. So you give you a thumbnail for what you could feel. Here's the potential exposure that you were talking about. The potential exposure is, as an example, if you paid $100,000 over the course of a year to independent contractors, and you've been doing that for the last 4 years because they can go back 4 years, all right? If you improperly classify them, based upon a lot of experience and what I've been through, you can basically expect a bill, both federal and state, for 50 to 60% of what you paid out to independent contractors. That includes the penalties and the interest and all the rest of that. So if you paid $100,000 a year over 4 years, that's $400,000. Guess what? You will come to your office one day and you will get a bill for $200,000 from the state or between the state and federal. And they will say you have 30 days to pay. Well, not only do you have now a $200,000 bill, now you got to pay lawyers and accountants to defend you in this. So now you're really looking at $250,000 or $260,000 exposure. This is why it affects the independent contractors themselves. Not a whole lot of hiring parties want to expose themselves to this type of liability. I always get people going, oh, what's the real chance of me getting caught? The first thing I say is take a look at Uber. Take a look at DoorDash. They got creamed until they got, spent $90 million for their own proposition so they can personally be exempt. Not everybody's got $90 million for a proposition, I'll tell you that much. But the bottom line, this is how you get caught. You can get caught if your independent contractor hurts him or herself at your premises or while working, and they're smart alecky enough or not smart enough, and they make a workers' comp claim. All of a sudden, in that situation, the EDD is going to come out and audit you. They're going to call that person an employee, and worse yet, you have penalties on top of what I just talked to you about not having workers' comp insurance for them. And let me tell you something, the workers' comp judges, whom we call the second lawyer for the workers' comp claimant, yeah, it's kind of true. They will slam you because you did not take out workers' comp insurance for that employee or that putative employee that got hurt. How else can you do it? Well, if that independent contractor is peeved at the company for whatever reason and goes and files an EDD claim. Oh, sure, they know they're independent contractors, but they're going to go and make everybody's life miserable by filing that claim. And they may not, in fact, be deemed an independent contractor, and that's when the EDD comes and slams you. You can also have a group of your independent contractors or anyone file one of those, class action, PAGA type lawyers. And not only are they going to sue you for misclassification, but then they're going to sue you for violation of wage and hour laws, meal and break laws, overtime laws, insurance laws. You're in a world of hurt if something like that happens. Of course, one of the other things, you can get an audit by Cal OSHA. Someone complains that one of your people didn't strap in when they got on a lift. All of a sudden, Cal OSHA will be there and they're going to audit who you pay, and they're going to find out if you have improper independent contractors. And then last but not least, it's rare, but it happens. The FTB, Franchise Tax Board, and the EDD, Employment Development Department, which is the labor department, they actually do random spot audits. I had a client nailed with one of them about 4 or 5 years. Was not fun. All right. So these things do happen. And again, I'm telling you this as independent contractors yourselves, so you have an understanding of the types of risks that businesses just simply knowingly, if they know about these risks, will not take just because you want to be an independent contractor. All right. So let's talk about what the test is. All right. We know that we just heard the parade of horribles. All right. We just heard how you could possibly get caught. Well, what are the rules of the road? Well, now is the time to go over them. All right. As we talked about under AB-5, and I'm going to call it AB-5 because we all colloquially call it AB-5. So under AB-5, there is what's called the ABC test. You have to meet all 3 prongs of the ABC test. It's a typical legal 3-prong test, but everybody loves to put fancy schmancy names to it. But the reality is it's real simple. It follows what the law of Dynamex laid down, the Supreme Court in July of 2018. And they basically said everyone in the state of California that is hired for their services is an employee, unless you could show you meet all 3 prongs of this test. All right, so what is a test? Listen, I could read you the statute all day long. You're not going to know what the test is and how it's applied. So I'm going to talk about it in very plain, simple language that normal humans understand, as opposed to these C-student lawyers that write this statute. At any rate, so the first prong of the test is that the party rendering the services has to have absolute and true independence in the rendering of the services. That means that they're not supervised. They're not told pedantically each and every step that they have to take. They bring something to the table, experience, knowledge, whatever, that they can work on their own. They're not told what time to come in or what days to work. They're not told what hours to work. That's within their own independence. They are not, I mean, you certainly can tell them when milestones have to be completed. You certainly can comment on their deliverables and make them make changes to their deliverables. But the bottom line is they bring skills to the table which are non-typically employee skills. If you think that your independent contractor is going to sit in your manufacturing plant and build your widgets and they're going to be called independent contractors, you're wrong. It's not going to happen. Possibly, if you send out all of the pieces to the widgets to people at their homes, and they put these widgets together without supervision or when they have to work or how they have to work, but just a deadline to return them, and you pay them on a piecemeal basis, possibly they are independent contractors, okay? The important part about Prong A is it re-verifies that you absolutely need a written contract if you're going to have an independent contractor. You could meet all of the requirements for an independent contractor, but if you don't have a written contract evidencing that, and the new part of the statute is that the hiring, in fact, follows the terms of the written contract. Remember how I told you before, we just wrote a contract and it didn't matter what it said. Well, now you have to have a written contract and they can question you as to whether your relationship followed the terms of that contract. However, you have the written contract and you have the independence, you satisfy Prong A. Now we go to Prong B, which is the prong that kills everyone. This is the prong that killed Uber. And that is your independent contractor cannot be delivering your service to your customer directly. All right. To give you an example, the Uber example, the Uber independent contractor, the driver, was actually delivering the service to move the party from one location to another. It was not Uber, it was the independent contractor doing that. That's the no-no. That's the violation of Part B. Real simple. If it's administrative stuff that the hiring party is hiring their contractors for, and you independent contractors that help businesses with their administration, you're pretty clear. You're not delivering any service to the customer of the hiring party. You're delivering administrative services to the customer. So to give you an example, an outside bookkeeper, an outside HR professional, although that is a specific exception, anything like that, an outside CFO, anything like that will satisfy a Prong B, all right? Questionable things. What happens if you have outside salespeople? Is that a delivery of a service directly to the customers? Or is that an administrative matter that you need to make sales in order to operate your business, right? They're selling something, they're selling a widget or a service. So it's a gray area. And this is the kinds of things we look at because a lot of companies work with entire staffs of independent contractor salespeople, all right? So you've got to make sure that you satisfy all of the prongs and you'll be closer to satisfying with an outside sales staff. You got to satisfy all three prongs. And there is a third prong to this test. It's the C prong. And the C prong is that independent contractor is in this business as a profession. And that independent contractor is rendering those services to other companies as an independent contractor, the exact same services. Again, give you an example. Your independent contractor bookkeeper works for you and 22 other people on a part-time basis, all right? So that's the ABC test. If you do not satisfy all three prongs, by default, you have an employee and not an independent contractor. Now, there are exceptions. And the reason why there are exceptions is because we have things called lobbyists. All right, let's be real about this. These exceptions would not exist unless big money came in to buy these exceptions, just like big money came in to buy the proposition. And that leaves all the rest of us to deal with these rules. All right, so we have to deal with them the best we can. However, I'll give you examples of the exceptions. If you have a regulated professional, in other words, a professional is licensed and is regulated by their licensing body, typically, specifically lawyers, accountants, architects, doctors, things like that. Those are exempt. Those can be independent contractors, even if they do not satisfy the ABC test. All right. There are a number of very specialized exceptions, but I want to talk about two of them. One of them is what's called the business to business exception, meaning they want to give an exception if you're a real business offering a service to a real business. The problem with that exception is that it has 8 or 10 separate qualifications to meet that exception. And again, one of those qualifications, there's a lot of them, but one of those qualifications that kills everybody on the business to business exception is the same as prong B. And that is they can't deliver the service directly to your client. There are ways to get around that. I'm going to talk about this right now. There are ways to get around that. If to give you an example, if your independent contractor, say, is a court reporter that takes deposition testimony. Well, what is it that the lawyers are buying? They're buying the deposition testimony in a transcript. So the court reporting company is not delivering anything other than what the court reporter is delivering directly to them. So they would have a problem hiring that court reporter for their business to render the services. So what do? They got smart, all right? They add to what the product is that they're selling. They not only sell that transcript, but as part of what they're selling to them is an ASCII disc, a keyword disc, so you could search it, all sorts of other things. There is all sorts of things you can do to add to what your independent contractors are doing for your clients that take it out of the realm of delivering the exact service to your client. All right. So keep something like that in mind. You independent contractors, keep that in mind. All right. So that's the business to business exception. By the way, this is hilarious. I can't tell you how many times somebody comes to me and says, well, my buddy Fred down the street said, there's a business to business exception. And as long as I incorporate, I'm safe. We're good. And all my hiring parties are safe. I'm like, yeah, does Fred have malpractice insurance for telling you that? Because I got to tell you, it's wrong. The mere fact that you're an LLC or an S corporation or even a C corporation, you're the only person rendering that independent contract service on behalf of that company, that does not take you out of the ABC rules. So that's something to keep in mind. It helps if you are. So we do everything we can to satisfy these rules. It's about nuance. It's about a little bit of sophistication now in order to satisfy these rules to get what both, frankly, the business owner and about 90% of the independent contractors want. About 90% of the independent contractors do not want to be an employee for anyone. So we as lawyers have to figure out a way that we can meet the compliance of these standards and not run afoul and risk the parade of horribles that we just talked about. All right. One more major exception that I like, it's a bundled exception, just like the business to business. And this is what's called the professional services exception. All right. These are specific services. To give you an examples, outside HR specialists are exempted. Well, it doesn't take a rocket scientist to figure why they exempted them, because the labor clauses, I told you, are so complex that they want companies in California to have HR specialists so they comply. So HR specialists are exempt. There are marketing exemptions. There are motion picture television exemptions. Yeah, they got a lot of money to lobby. There are publishing exemptions. There are arts exemptions, meaning literature, performance art, music. There's all sorts of exemptions. So you can hire independent contractors to put on your, once in 6 months symphony. All right. Education exceptions, things that are done for educational purposes. They don't want to kill you there. But the bottom line is this. Let's step back and go right to the bottom line. The bottom line is this. There's no way that an unskilled professional can know whether they have an independent contractor or they have an employee in the state of California. It's almost virtually impossible for someone not skilled in these things. So here's my recommendation. Both from the independent contractor side and from the hiring party side, it is absolutely worth it. It is absolutely recommended that you get either an HR professional or a lawyer who knows what they're doing in this stuff, and not all of them do, that can review and analyze your business and, more importantly, your particular independent contractors that you want to hire on a case-by-case basis. Because if you don't do that, you are not planning. It is not a prudent business approach to go on by guess and by golly, because if you trip up, like I said, the costs are ridiculous. Excuse me. So what do we do? Let's say you get this analysis. What do you do? Well, first of all, you need a written contract. Even if you qualify under the ABC test, you need a written contract. And that written contract has to hit all of the requirements, that you make sure that you have evidence of all the requirements. And to do that, with my contracts these days, I have them put on their website a homepage as an exhibit to show that they are offering these services out there to other people. I put their business card as an exhibit to show that they're in the business independently of rendering these types of services. I also do things for both sides, quite frankly. To give you an example, I represent a lot of independent contractors, which at the beginning were being told, we're not hiring you anymore. As a matter of fact, there were a number of lawyers that were doing classes at the business and law school at UC Irvine that had it all terminated because they were afraid of causing a problem. Well, after I got done with them and showed them what to do and how to get it done, they're all back working. However, what we do have to do for the independent contractors is in their contracts, when I represent the independent contractors, when they offer the contract to the hiring party, in their own contracts, they are indemnifying the hiring party for an adverse ruling as to whether they're an independent contractor or an employee. Well, what's the risk there? Here's the risk. The risk is about less than half. The risk is 20% of what the liability is for the employer if you didn't indemnify them. And here's why. As the independent contractor, you have control of whether you pay your taxes or not. If you pay all of the appropriate taxes on the payments that you receive as an independent contractor, all that list of its horribles, all that exposure goes down drastically and dramatically. All right. So because as the independent contractor, you have control of that. Why not start out with the people that are trying to hire with you and give them the comfort of giving that indemnity, when really most of that liability is under your control. All right. There's other things to do. All right. I will tell you that I have clients that pay independent contractors $200,000, $300,000, and $400,000 a year. Big construction companies. These are construction managers, independent contractor managers. What we also require is insurance to be purchased by the independent contractor to back up the indemnity. Because if that independent contractors make $400,000 a year, after about 5 or 6 years, takes off to his island in Aruba that he bought, you're not going to find him. And there's no way that you're going to prove that he actually paid his taxes, and you're going to be stuck with the full liability. So for situations like that, you could also equally give assuredness as an independent contractor to your hiring party that says, hey, not only have I given you an indemnity for this, but I'm going to buy insurance to cover you for this. So here, come on, there's no risk, hire me. All right. This has been a struggle for a lot of independent contractors recently, but there are solutions, and there are ways to address this. And there are ways to keep your independence as independent contractors. And frankly, your hiring parties want it that way. All you got to do is give them an excuse to get it done. All right. But let's say the world falls apart. Let's say you can't get that done. You can't qualify under the ABC test. You can't qualify with respect to an exception. All right. There are other alternatives for the hiring parties. Not as many for the independent contractor, but for the hiring parties, number one alternative, bring them on as employees. Not every independent contractor is going to want to do that, but you bring them on as employees. Alternative number two, you can make staffing arrangements. You could tell that independent contractor as the hiring party, look, I use this staffing company, and I will hire you as a temp, and you can work for that staffing company. And then you don't have to worry about it. And then you can work for several different companies. It's not preferred, but it can work. And the last alternative for the hiring party is a company restructure, to restructure how their operations are done. So, and there's many, many more things that I don't even have the time to cover. I just want to get across something very, very important. And that is, this has changed law. This has changed law forever. This changed law has consequences if you don't follow it, if you do not comply. So if you take only one thing out of this whole presentation, that is, if you are hiring an independent contractor in the state of California, have a professional take a look at the circumstances and give you that professional advice as to what you need to do. Thank you. I hope everybody's got them. Happy to answer questions.
Thank you so much, Lee. I'm going to go ahead and see if I can't remove that. Okay. So we do have a couple of questions. The first one is, as a solopreneur with an EIN, can I work in a business-to-business exemption?
As the independent contractor or as the hiring party?
Sherry?
Independent contractor.
Okay. As the independent contractor, you can do whatever you'd like. It's getting the hiring party to hire you and take the risk. So on a business to business exception, the mere fact that, I think the question was, the mere fact that you're a corporation or you're an LLC or an S Corp will not save you or create a de facto business to business. They will look past it for all of the other indicia in there, all right? And if that was the question. But yes, as a solo practitioner, as an individual, whether you're incorporated, whether you're an LLC, or whether you work as a sole proprietor, you can qualify as a business to business, but you got to satisfy all of those 8 to 12 requirements to do so.
Now, Lee, what if the client is out of state?
Well, if the provider of the independent contract services are out of state, their state governs what it is. I tell my clients with impunity, when they have reps in other states that don't employ this type of classification, I tell, hire them with impunity, no problem. I got plenty of clients that have their entire research facility of independent contractors in Arizona. No big deal. They're not governed by California law. The jurisdiction of where the employee / independent contractor lives is the jurisdiction that governs.
So that just makes more jobs leaving the state of California.
Yeah, that's exactly right. Send more jobs overseas and more jobs out of California, but that's never been a concern of the California leadership, certainly of late. They don't care whether you're here for business or not.
Okay, so what if the contractor is in California, but the client is in, say, Arizona?
Yeah, I will tell, the hiring party is in Arizona.
Yeah, the hiring party's out of state and
Right.
the contractor lives in California.
Right, what did I just say? It's the state of the residence of the independent contractor / employee that governs. So all of those companies that are out of state that have local independent contractors and don't follow these laws or don't understand that these laws even exist, they expose themselves seriously. As a matter of fact, I just straightened up issues for a major national company that a fitness center place that hired a bunch of independent contractors all over the state. And they came to me and I basically said, hey, look, man, you got 200 people ready to turn around and sue you. If you think the state's not coming after you over that, you're out of your mind. And we fixed it and straightened it out. All right, so yes.
Okay, well, that sums that up. Okay, next question. How does the law affect organizational consultants and coaches?
Yes, organizational consulting and coaches, you remember, you still have to meet the 3-prong test. But the second prong, which is the hardest prong, Prong B, is already satisfied. Remember, coaches and organizational consultants are giving services to the company itself. These are administrative services to the company. So the hardest part of that test is already satisfied. You're not giving it the services to the customers of the company. So obviously they're well-trained. They know what they're doing. They are certainly independent. They are not working there 9 to 5 or any particular hours at any company. It's pursuant to a contract of what they're delivering, right? The last thing about that is, presumably, those consultants and coaches do it for a living and give it to other people, right? So the bottom line is anything that is administrative, coaches, consultants, financial administrative, organizational administrative, that's all well within the ABC test. And you probably are going to be okay, probably.
So we have a lot of like creative, like graphic designers, web developers, marketing, copywriting, social media strategists, that type of marketing services. I'll just kind of encompass it in. Would those consultants also fall in line with that?
Yeah, as a matter of fact, I represent a number of marketing companies, and I will tell you that there are two general business structures for marketing companies. One is everybody is in-house, and you'll usually find them, in New York or Dallas or something like that, LA. But the vast majority of marketing companies use independent contractors to get all of these things. And I represent a number of them, and I have developed and there are, in the exceptions, there's a lot of stuff for graphic designers, an exception. Web developer is in the exceptions. Copyright writer, not copyright, but writers of copy are in the exception. Marketing is in the exceptions, but you have to develop the agreement that shows that you're in part of these exceptions and get all of those evidence in the indicia as an exhibit to prove up that you meet these exceptions. Yes, my marketing companies, I think I have 7 or 8 completely different agreements for their different independent contractors in the different disciplines that they use for their marketing company, right? So yes, absolutely.
And then so for some of us on this particular group, because we are kind of solo entrepreneurs, a lot of us, how does that independent consulting jobs that are found on like Upwork or other online job marketplaces, how does that apply? And then are there special considerations for that kind of online gig work / job marketplace?
Yeah, look, understand something. That online stuff, these job posts, these job sharing things. Somebody recently showed me one where you can go online and you can pick your price for your logo from
yes, that's exactly what we're talking about.
$5,000 or something silly like that. First of all, understand a lot of those contract providers are outside the state of California. So it doesn't govern them, and you could be just fine. If you're on there as one of those providers,
yes,
your companies will be subject to the laws if you don't qualify. In other words, a lot of those things, there are never a written contract to do it. They hire you on terms that you go back and forth. You get a quote online. Okay, I'll do it. Yeah, I'm great. Done. Right? You don't have a written contract, you're not a qualified independent contractor. It's just that simple. All right. So what ends up happening with those things, mostly, it's not a problem because it's out of state. For the people who put their name, it's not a problem for them. They're not the hiring party. Any hiring party that goes on those websites to hire people, they're not concerned with AB-5. I'm telling you that right now. All right, they're just not. And then the last thing to understand about those websites, there is no difference between the way those websites operate and the way the Uber operated, except in one specific aspect, and that is that the user contracts directly with the service provider. You don't contract with the online website. You're contracting directly with the service provider, and that breaks it down. It breaks it out from being very similar to an Uber situation, right? And that makes a difference for a lot of the exceptions. That's a big deal. That's a huge deal. I mean, Uber could have put together a structure where they hooked everybody up, but it was the drivers who negotiated and got paid directly, and they paid Uber a portion. That would have been fine. They would have not violated the law. However, they wanted to keep their structure and thought $90 million was worth it. I probably think they were right now that they got it, what they wanted.
Right? Okay, I have a couple of questions here from Jasper. I hire independent contractors. Is it possible to have an omnibus contract that I can have them sign? Or does each contract have to be customized? What might one expect to pay for an agreement like this if they possibly have to write one?
You know what? That's a very insightful question, actually. That's really somebody who was thinking, I don't know where that came from. That was very smart. Because here's the situation. Under the old law, we had 21 indicia and everybody hit the 21 indicia, right? Because you looked at the nature of the relationship and not who the contractor was and what they're providing. The way this new law is, the focus changes. The focus changes from the relationship to who the independent contractor is, really. And here's the problem. There is no way anymore to do one contract. Now, certainly, I could do one contract for every web designer that you hire. I could do one contract for every copyright writer that you hire. I could do one for every photographer that you hire. I could do one for each one of these different structures has a different exemption or a different qualification. Now, here's the one thing that you do get. Everybody, no matter what their job is, if they qualify under the ABC test, you could throw all of your ABC qualifications under one agreement, no matter what the job is. But other than that, if they have to rely on an exception to qualify, every single one of those contracts are different.
Sorry, that's my dog asking you a question. How much can one expect to pay, like a ballpark, just like a range of what the contract like that might cost?
It's all over the place because the talent is all over the place, quite frankly. New laws, there are a lot of generalists that think they understand this stuff and are charging accordingly as if it were not something special. All right, but it is something special now, and it does take an analysis now, and any lawyer worth their salt is going to tell you that my liability is out there by me telling you that this is an independent contractor. So for me to say that now I have to charge accordingly, right? So whereas before an independent contractor agreement in old terms, remember you could use the same agreement, just change the duties and the compensation, right? So it's not a big deal. In the old days, those contracts were between $1,800 and $2,500 per contract, typically. I did some special deals for my clients because I happen to like to give my clients a form and teach them how to fill in a form. So I have different charges for templates, so to speak. I will tell you now, it does cost significantly. I can only tell you what my rates are. Is that something that you really want to hear here? I'm happy to do it.
Yeah, I think that it's good to kind of understand what we're talking about because you kind of gave us the breakdown of the worst case of what we might have to pay if we don't follow these guidelines. So I think it would be beneficial to hear the other side.
Okay, so here's the deal. I charge fixed fees to my client. Different people do it different ways. I charge fixed fees to my clients because my clients are businesses. And businesses cannot have an open checkbook based upon how many hours it takes you to get something done. They have to budget, right? So I give fixed fees for everything that I do. I'm transactional based. It's easy to do it that way. So here are my fees for, it's real simple. If it's an ABC qualification, first of all, every one of these fees includes the analysis. So it's not really a fee for the contract. It's a fee for the analysis and the contract to back up the analysis, right? It's two different types of things that we do. So in that fixed fee, if I were to prepare for all of your ABC qualified contractors, right? I would give you a form. I charge $4,500 for that form, and you could use it for every one of your ABC qualified contractors. And when you come to me, I make the determination which are ABC qualified and which are not, right? I take a look at that. And that's a legal opinion that, you know, like I said, that's our liability if we're wrong. That's why you come to a lawyer to get what we call a safe harbor, right? There won't be penalties typically if you had a safe harbor. You went to someone, you got poorly counseled, if you will. However, so that's for the ABC test, all right? I charge exactly the same for each different exemption contract. In other words, if you qualify on the business to business exception and you have a number of those, it's $4,500 for the form. If you have a number of professional services exemptions as hires, it's $4,500 for that form. But I offer a second thing because sometimes businesses don't have multiple independent contractors or numbers of them in the same category. All right. So what I will do then is, let's say they have 2 or 3 independent contractors. I prepare 3 direct agreements. And if it's to give an example, if they're all 3 are ABC agreements, I charge $3,500. Remember, $1,000 off because I'm preparing a specific agreement you're getting in PDF, not in Word for you to use. You get the specific agreement, and then I charge $750 for each additional one that I complete to put in there, right? Mm-hmm. So at some point, it's more worth it getting the form than it is getting me to fill out each and every one and review each and every one.
Yeah, absolutely.
And apply it to every one of the separate exceptions. If I have to prepare a contract or a number of contracts for a business to business exception, if I'm giving you a form that you could use in perpetuity, $4,500. If I'm doing the specific ones for you for that business to business exception, it's $3,500 plus $750 for each one that I complete after that. If in fact you have different business to business exceptions, they all start out at $3,500, or for whether it's a form or a specific one, they all start out at $4,500 or $3,500. And again, the prices have gone up for that amongst all lawyers that know what they're doing in this stuff, because the liability is so great and the technical aspect and the technical knowledge you need to understand this is so high that really what you're getting is older experienced lawyers that have been working under both structures, so they understand how to satisfy what's changed here and what's different.
Yeah, that makes a lot of sense, since this is a new law, but it's built off of the older existing law. So that makes a lot of sense that you phrase it in that way. We have another question that's about the, maybe can you review the indemnity language to protect the hiring party?
I can't, can you talk slower so I could hear you?
Sorry. Can you review the indemnity language to protect the hiring party that needs to be in a contract?
I not only review it, I prepare it. Yes, I know what they should look like. Listen, I do everything from people bringing me their contracts to review and say, does this qualify? Are we good? To starting out and just preparing a contract with no consultation. So I take no responsibility for how they wanted it, right? To doing a full consult. And the prices I gave you were for a full consult to go in and do that, okay? So.
Now, what about if the, like when you're dealing with clients that are out of the country, like maybe they're in Japan or maybe they're just not in the United States. How does this affect the fact that we would be here in California?
Well, you keep saying the client. You mean the hiring party?
Yes, the hiring party would not be in California. They might be out of the country, but they're hiring someone in California.
Right. And typically they don't care what the state of California wants to fine them or assess them if they don't have local assets here in the state, if they don't have bank accounts, if they don't have real property. You know, what's the state going to do to a Japanese company that does? I mean, come on, really, honestly, right? But if they do, or if they're a type of industry that needs special licensing in the state, like an insurance provider, you're putting your licensing at risk. They'll pull it. They'll pull it if you just ignore them.
Yeah, no, that makes sense. We have another question that has to do with the arts. Can you tell us about the new bill for the arts that is up to be voted on this month? This is to be the small arts companies where the state would give grants to pay an employee and hourly expenses.
Yeah, this is just an expansion of the change from AB-5 to AB-2275, okay? There were extra exemptions in there for for the arts, okay, for the fine arts. There are people that think it didn't go broad enough for the fine arts. So they're bringing up other exemptions for them. I mean, there are other exemptions in there that are some of it's silliness, like an exemption for somebody who puts on to give you an example, one of the big issues, one of the big cases was the Renaissance Fair at Glen Helen Park, right? They put on that fair, everybody coming in there to work for all those booths and everything, they're all independent contractors. All the guys walking around playing their music, they're all independent contractors, all right? And it was not broad enough to cover all of those types of things. So they put in a special exemption for once in a while events and festivals, all right, to cover things like that. The arts exemptions are being expanded while the business exemptions are being contracted. I just want to let you know that. To me, that's fair. My God, if you cannot hire independent contractors and you're in the arts, you're going to kill the arts. It's stupid. You're going to kill business, but business always finds a way, right?
Well, yeah.
When there's profit involved, you always find a way. That's the problem with arts. The arts are supposed to take care of your soul, not your pocketbook.
Yes, very true. We have another question that's about speaking to what you know about the PRO Act, and will this change anything for California freelancers, or will it be business as usual for us?
Will AB-5 be business as usual for the freelancers?
Well, no, the PRO Act.
I didn't hear what you said.
The PRO Act, PRO Act.
I have no idea what the PRO Act is.
I think the PRO Act is what they're talking about in government, but I'll let her pop in.
I'll pop in.
If it's about, go ahead.
It's the federal legislation that's in the House right now that mimics AB-5 at the national level.
Oh, okay. I gotcha. Let me tell you something. When our president was campaigning and AB-5 everybody was screaming about it in the beginning of 2020. This administration strongly supports an AB-5 type structure. Why? They get to control more people. It's just that simple. And that's why the state of California wants it. I mean, if you're an employee, they tell you, oh, I'm sorry, you can't work through your breaks. We get to control you and tell you how to work through your breaks and things like that. The federal government enjoys that type of control over people too. And by the way, I'm not talking any political party. I'm just talking about in general. I will tell you that there are 18 states currently considering some form of AB-5. And I think that we're going to see some form of AB-5 at the federal government level beginning of next year. And the reason why I think that this is going to happen is because it creates a huge question of law. And that is, can you treat someone as an independent contractor, as an employee for California purposes, but there is no federal law. The federal law is like the old Borrello law, right? That we used to do. It has your indicia and you work through all that. So the federal, can you treat one person differently federally and state? I think that's incredibly dangerous. Some people are starting to do that, and it is incredibly dangerous. So I would like, look, we're going to see it. We're going to see it on the federal level. I had no idea it was called the PRO Act. But I will tell you, there will be a lot of fight about it, because remember, California, we've been whipsawed around businesses. I'm talking about businesses. California business has been whipsawed around by the California legislature for 20 years. All right, it's been really bad since probably the Wilson administration. And it's gotten increasingly bad. When I say bad, increasingly more regulated on California businesses since then. We're so used to it that we don't put up and fight over things like this. There are other people in other states that will. So
yes,
it'll
sir.
be issues for a while, and there will be a lot of dissent, a lot of dissent. And if you don't think that if you think it's just the southern states or the red states, you're out of your mind. You go to those industrial states, those people are just as vicious about their money. I will tell you that. So that's what I think is happening, and that will come down.
Now, with that possible federal regulations coming in, does that mean that these type of borders that we talked about earlier with California versus Nevada and out of state, out of country, do we think that that will be blended so that these types of contracts that you're talking about that you provide will become necessary in order to continue doing business?
It will be, look, the way it's going to work out is the most restrictive rules are going to be in effect, because remember, the supremacy clause says that the federal government, and remember, this is interstate commerce, they get to regulate it. So they can make a law that the states, if the state laws are in contravention of them, or they're more lax, in other words, you're still going to have to satisfy the more restrictive law. I do not think, because of what we just talked about, I do not think the federal law will be more restrictive than, I don't think it'll be harder than California law. I really don't. Because, I mean, it's hard on California businesses right now, all right? I don't think the whole country will put up with what California business puts up with. So I think there will be this law, absolutely. But I think it'll be a little softer, i.e. more exemptions.
Yeah. So if you say you create like a small website for a company, or you're hiring like a single delivery type project, or you're, doing an event for one night, those one-time single project type or a single events, would not be subject to the ABC test, or would those just be what's 1099? They
are all subject to the ABC test, but there is an exception for a festival type event. But let's all keep perspective on this, people. Let's keep in mind, if I pay $2,000 to an independent contractor because of one event, or $5,000 to an independent contractor because of one event, and they catch me, really, my exposure is $2,500. I really don't care. you got to get real with this. I mean, I'm talking people that have independent contractors as part of their ongoing business, right? My goodness gracious. I have a housekeeper. She would qualify as an employee of mine and every one of you that have housekeepers, all right? And she would violate every employment and labor law in the state. Okay, but I still do it. Okay, I pay X amount of dollars a week. You know, it's not, you know, $75 a week. I'm not worried about.
Right. Yeah, kind of back to where it's, you know, kind of that breaking point of, you know, paying for that template of the $4,500, right? So if you are issuing the AB test as an independent contractor, subcontract work to someone, can you subcontract work to someone who does work similar to what they do? So I think what Melissa might be asking is, if Melissa is a copywriter and she's contracting out work because she's overloaded to another copywriter and then maybe putting her twist on it and then providing it to her client, would that be an offense?
All my independent copywriter, independent contractors, all my copywriter independent contractors will all have the same form of contract. Yes, absolutely. So we'll all have the same requirements. I tell my clients, look, you know, it's best. I have clients that have paid for incorporation and websites for their independent contractors just so they could show the indicia on their contracts and agreements. Okay. So I've been through that process before, but yes, absolutely. If you're all in the same, remember, the exceptions, it all focuses on who the contractor is. So if all of those contractors are the same discipline, then the same contract is going to address it for all of them.
And then if they didn't have a contract and they were just rolling the dice, could they would be in violation of this?
If you have 100 independent contractors and they all satisfy AB-5 beautifully, but not one of them has a written contract, all of that parade of horribles will come down on your head. And you've qualified. So you've just created a silly situation in that situation, right?
So what you're saying is we should all have contracts for our contractors so that we have those plus the contracts that we have with our clients. And as long as we have files upon files and we all pay our taxes, we're all good.
Absolutely. I got to tell you something. The more you give them what they want, whether it makes a difference to you or not, the more you give them what they want, the more you get what you want. I mean, it's human nature. Come on, right? So if the rules are you have to have a written contract when you're the hiring party, hiring an independent contractor, you better have a written contract. And my recommendation, strong recommendation, is everybody who's working as an independent contractor, come to the table with either one of two things. If you're working with a really big company, they're going to give you the contract that they want for you, all right? But you come to the table with two things. You come to the table either with your written contract that you want to do, or you come to the table with an indemnity agreement, insurance agreement, representations and warranties, all of those types of things to add into their contract so they know you're serious as an independent contractor. I'm going to step up to the plate. You don't worry about it. Just hire me. All right. Though it works on both sides. You really got to get into the mind of playing their game and making your money, playing the game their way and making your money your way. That's really what it comes down to.
Yeah, that's a really good point. It's like, you have to know the rules in order to bend the rules.
I say it differently as a lawyer. You have to know the rules in order to comply with the rules. Okay?
Created. So I'm going to go
Because I get around something doesn't mean I'm not in compliance. Compliance is the important part.
Yeah. So I think I know that it's definitely confusing, you know, to kind of, like you said, this is a confusing topic and everyone's situation is different. And whether you're a designer, a copywriter, a developer, an artist, you know, whatever your trade is, your craft, and you subcontract out that same craft or even parts of that craft, you're going to probably need to hire someone like yourself to write that contract so that you are covered as the business owner.
I agree. And I will tell you this, again, it's the analysis. You know, everybody says the funny part about it is we charge based upon the written contract, but the real value is the analysis. All right. It's the determination of where they fit. And then the contract is just documenting where they fit. All right. That's the way to look at it. So really, if somebody would come to me and go, well, what do you charge for your consultation, and what do you charge for putting the contract together? On a $4,500 contract, I will tell you I charge $3,500 for the consultation. Absolutely. That's where all the value is. The contract is just giving effect to what you've just consulted about. Okay?
So we have well, actually we have a couple more. So do you still have a couple more minutes, Lee?
I have until 7:30, and then
Okay.
I gotta bug out.
Perfect. So for the exemptions, there is a no-low list that seems good. Any others to suggest?
I'm sorry. Can you say that? I didn't understand that.
Is there a website or a specific list of exemptions, or would they be in one of the 3 articles?
Oh, yes. I will tell you the list of exemptions. Hold on one second. I will tell you the code sections. And you look straight at, and by the way, they're written by lawyers who couldn't get jobs in the private sector. Okay. So be patient with reading through these.
Yeah, it's like the nolo.com, right? The NOLO.com.
You can, or you could just print this, or you could just put this in your search engine.
Oh.
California Labor Code sections 2775 through 2787. 2775 is the ABC test. Everything else, 2787 is some administrative things, but everything else in between are your exceptions. Okay?
Perfect. And then one last one. I was feeling disheartened because I'm such a small business and don't have the resources to be able to get these expensive contracts and consultations. Because I give all my clients a contract that defines the project with an indemnification clause and pay my estimated quarterly taxes and can pass both Barillo and the Dynamex. I feel more comfortable now than I have in the last 2 years. So I think that was a thank you, and for all of your knowledge and just straightforwardness and not talking to us like a lawyer, even though you do have to have the lawyer speak.
Well, I will tell you, I'm very happy to talk about this stuff because here's the deal. It's a highly technical field. Business owners know their business. They're not expected to know these technical things. But if you run afoul of these things, the consequences, you know, you might get away with it once in a while, but the consequences of a really bad trip up could bring your business down. And that's not what I want to see. I would much rather see a business that doesn't have a lot of money to spend on these contracts, just at the baseline, get the consulting and know where their exposure is. So, okay, you don't have the money to put these contracts together. You're taking your risks because of how much you pay to independent contractors. Maybe it's not a lot, maybe it's little, whatever. But if you don't know your risk as a business person, then it's like having a rudderless ship. Okay, you don't get to the place where you're going without planning and knowing and expecting and having alternate plans in case things go sideways. All right. I'm really big on operating. I'm outside general counsel. I'm really big on operating your business with intent. And this is just part of that intent. You need to know whether you are operating, and if you're not in compliance, and if you're not, know what risk you're taking at the very least.
Yeah, that's a great point. Well, Lee, I would say thank you so much for your time and all of your knowledge. It's been extremely helpful. And you were the perfect expert for me to think of for this event. And you've been so knowledgeable and so forthright with your information and even estimates on what things cost and what to do and what not to do. I couldn't have chosen a better expert / speaker.
Oh, thank you. I am flattered and humbled, Bridget, because I have huge respect for you, and you know that.
Thank you so much, Lee. And thank you to everyone who attended our May Spark. And I look forward to seeing all of you in the summer months. I think we will still be on Zoom at least through probably June and maybe July. But hopefully sometime in the near future, California will actually open up and we'll be able to see each other in person.
Well, you all have a great evening. Thank you for having me.
Thank you so much, Lee. Bye, everybody.